Lovely. Okay. Hello, everyone. My name is Zoe Chapman. Welcome to the first in this latest series of lectures brought to you by the J6 group at Red Lion Chambers. If you've been to these seminars previously, you may notice I'm not the usual person who introduces the speakers, and that's because Nicholas Hall has recently stepped down as head of J6 after an almost despotic number of years, and I've taken up the reins. So thank you for your service, Nick, if you're watching. Just quickly before I introduce this evening's speakers, just to let you know that the next J6 seminar is on the 21st of April, and Josh Ellis and Letitia Egan are presenting that one. We don't know as yet what the subject matter will be. And it may be, I'm unsure, sorry, but it might be that we were able to return to an in-person format by that stage, although I think there will always be from now on a Zoom option as well. We have this evening Laura Jane Miller and Anita Clifford talking about the subject of recent developments in criminal justice diversion schemes. Without saying too much, this talk comes in the context of an increase in diversion schemes and an increased focus on restorative justice and rehabilitation in recent years. Various particularly public issues such as the potential diversion of pregnant women from the prison system. Over the next hour-ish, Anita and Laura are going to provide an overview of recent developments and prospective measures which may assist defendants. I'm told that, as usual, the slides and the video of this seminar will be available on our website afterwards. If there's time, there will be a Q&A afterwards, but if we overrun, then we can provide an email address for any questions to be sent to. And so without further ado, I will now hand over to Anita.
Thank you so much, Zoe. Well, good evening, everybody. My name is Anita. Tonight, I'm very pleased with Laura Jane to be approaching this topic of diversion. We have about 45 minutes of discussion for you, and then there'll be an opportunity for questions. If you have any questions, please do feel free to type them into the chat box, and we will get to them at the end. But what is particularly interesting about this topic of diversion is the renewed interest which does surround it as a result of the increasing pressures that we are facing in the criminal justice system. And that is why diversion is particularly interesting to me and also to Laura Jane. Now, the words being tough on crime are really an age-old political winner. And in recent months, indeed, at the start of this year, we saw headlines announcing that more prisons are going to be built, that existing prisons will have their wings expanded, and also that magistrates' courts' sentencing powers are going to be increased. Although these are the measures that have attracted a lot of attention, there are also continuing efforts to divert people away from the criminal justice system, but they are happening rather quietly. The government's own Beating Crime Plan, which was published in October 2021, so just a few months ago, did make references to diversion. It highlighted promising interventions to divert young people. It also highlighted wanting to divert people with drug addiction away from the criminal justice system and into out-of-court disposals. What this shows is that diversion options are available. It really is just about knowing where to look for them, a bit like looking at that big report and seeing the references to diversion being buried in that report. What are we going to be covering tonight? So I will be covering the first part of the session. I'll be looking at some of the key concepts behind diversion. I will be looking at the current debate. Certainly on one side of the coin, you have calls for more prisons, and yet on the other, you have really big calls as well to focus on rehabilitation. We will then be turning to some pilot programs which have had, it must be said, some varying success, and then looking at some practical tips for practitioners. Laura will then be going through the ins and outs and the real practical components of drug diversion and youth diversion. So that is where we are heading this evening. To start, if we can look, I suppose, at some foundational concepts. What is diversion? What exactly do we mean when we're even referring to it? I think at the outset, it's important to recognise that there is no universal definition when it comes to diverting people away from the criminal justice system. There's certainly not a one-size-fits-all scheme. Rather, it's a collective term, just as Zoe said at the beginning. It really has come into some focus in recent years. And about 20 years ago, you started seeing some headway being taken on in the form of youth justice diversion, and then later perhaps mental health diversion and drug diversion to follow. So it's all been an evolution in the past 20 years or so. It is as well not just a resolution of a potential criminal matter, which diverts that person away from the criminal justice system, but it's also the process of doing that and the outcome as well. So it can be have these two twin meanings. Ultimately, though, I think it is, and across the board, the different schemes all have this in common. It is about diverting somebody without the need to prosecute them. That, at the end of the day, is what we're referring to. I think typically it happens in an ideal world pre-charge, but equally it can happen at any stage of the criminal proceeding, including when a person has been charged, and indeed including when a matter has already been set down for trial or is quite advanced in the proceedings. And I think additionally, all of us here as practitioners might be used to seeing diversion in one form or another, particularly for youth offenders. But there is actually nothing to stop it being used far more widely, not just for adult offenders, but indeed those who commit not just minor crimes, but potentially more serious matters such as offences against the person or offensive weapon matters as well. There is nothing to prohibit it being used more widely. That said, although there's I suppose, disparity in how the term is used, and certainly a lack of definitional understanding, there are some common objectives to it. The idea being, first and foremost, to avoid over-criminalisation, ideally to put rehabilitation first and foremost. There is an emphasis on wanting to, at least in some of the diversion methods, bring the complainant or the victim more into the frame and give them a chance to speak and have their voice heard. There is an emphasis on accountability by the prospective defendant, and the whole purpose of diversion is not just to encourage rehabilitation, but also give the complainant, if that is the sort of crime that has been committed, a role in the process. So those are some of the common objectives across these different diversion schemes that we see. In practice, so that all sounds very lofty and idealistic in terms of the goals of diversion. What then is the practice here day to day? So certainly the diversion schemes, they can have a statutory founding. They can be set out, as is the case for youth matters in LASPO, but also they can have a non-statutory basis as well. You probably, or all of us actually, would be familiar with the ideas of a caution, reprimand, or warning, which tends to have more of a statutory basis, particularly when it concerns youth. Additionally, there's a lot of guidance that has been published, and I've put some of the links there as to when a caution might be a suitable disposal for an adult, and that's all the subject of guidance. But away from these more formal out of court disposals, which have been around for some time now, there are also non-statutory options as well. And they can take the form, and it's quite varying, but they can take the form of restorative justice meetings. They can fall under the banner of a community resolution. There can also be, depending on what's on offer in a particular local area, diversion or informal diversion to particular rehabilitation programs. So statutory, non-statutory options, formal and less formal options as well. And I've put, when I've referred to restorative justice, what that means. Basically a face-to-face meeting quite often to discuss the matters giving rise to an offence, which happens with a facilitator, often without any lawyers present. Looking further at the practice, I think it's also fair to say that the experience of diversion is very much a mixed bag. In the main, it's going to be police-led because they are at the front line of dealing with people who are prospective defendants. And certainly the research, recent research does show that the vast majority of police forces do offer diversion in some capacity. But additionally, although it is on offer, just what it's on offer does vary. The sorts of prospective defendants who would be eligible also varies between different police forces. And even to get to the point of a diversionary scheme being offered is very much dependent on there first being a rather small pilot program, which is then rolled out later, either in that particular borough or in that county. So certainly there's not a consistent framework either across police forces, across areas at all. There's also in practice problems with recording what happens after a diversionary scheme is offered. Of course, a prospective defendant might be very eager to take that up, and that is then, I guess, followed through by them. But there's not a body of evidence as to how many diversionary schemes are offered, what is the take-up, and what happens after. And that tends to be coming through in some of the not necessarily opposition, but criticism to rolling out diversion more widely. Just for current context, in 2020, the Magistrates Association expressed concerns about the lack of data to do with diversionary schemes, and also expressed concern that it wasn't appropriate for more serious or violent offences, that they are more suitably dealt with in court. So that's the sort of criticism or opposition that one is seeing to the use of diversion. I think also it's fair to say that there is very much a postcode lottery. So this idea of disparity between boroughs, police forces and counties about diversion very much leads to a postcode lottery, and that can particularly affect youth offenders as well. This was raised very recently by an NGO called the Centre for Justice Innovation. And some of what they were saying is actually quite alarming from a practitioner perspective. Certainly they found that 115 of the 152 youth offender teams did have a diversion scheme of some kind, but 19 said they had no diversion scheme. And also of those that did have a diversion scheme, just how they were structured and what they required did differ wildly. So for instance here, and I've put it on the slide, 31% of the schemes didn't require a child to admit guilt, whereas the others did. And of those that did, you can see why that might be a disincentive to actually taking up the scheme. And then even in terms of those that required guilt, what exactly guilt meant in a particular context, again, differed quite widely between the different schemes on offer. So even in an area of youth justice diversion, which it must be said is the most mature and established of the diversionary schemes on offer, you do have these sharp distinctions, which is quite concerning. Looking more broadly at the debate, I think it is right to say that certainly a lot of the emphasis, particularly in COVID and how best to respond to the backlog, is to, at least at the political level, is to announce new sentencing powers, to increase not just court capacity, but increase prison capacity. And we see here the National Chair of the Magistrates Association, of course, well endorsing those recent announcements, particularly the extension of up to 12 months sentencing power for single offences in the Magistrates Court. But there is also some who would say that perhaps diversion is another way of doing things, not necessarily as an alternative, but something to complement these new powers that are going to be introduced, particularly given the current context, potentially a way to tackle court backlog, if one is most concerned with that. We are, of course, all very familiar with some of these rather bleak statistics in terms of court backlog. I looked up the statistics that were most recently published in December of 21. So in terms of backlog in the magistrates' courts, there is a talk of 395,000 cases which are outstanding. That is higher than what was regarded as the historical peak of 327,000. You then have in the Crown Court some 60,000 outstanding cases, again surpassing what was regarded as the previous peak. There's also some rather bleak news in terms of length of time. Some 189 days is being recorded in terms of wait time in the Magistrates Court. In 2020, more than half of Magistrates Courts trials being rescheduled. Therefore, one could say, well, is there a strong case for diversion because, at least on one view, it has the promise of swift justice? Just looking at, I suppose, calls for not just swift justice, but the context and discourse surrounding the case for diversion and where that comes from. Certainly there have been at the political level reports which have said that an out-of-court disposal does show lower reconviction rates. There was the Green Paper Evidence report some years ago now, which said that. Interestingly and really quite importantly, in 2017, the David Lammy review also said that pre-court diversion might be a worthy recommendation because in particular, it could reduce racial disparity and over-prosecution of BAME people. So that was recommended. You also have various think tanks and NGOs involved in this work who talk about the need to address causes of offending, relieve pressure also on the CPS and on the police. So those are the sorts of points which are very much raised in favour of diversion. I think though it's certainly the main refrain against it, and it's readily understandable, is that the court system and its strictures and the process of sentencing, it is seen as the biggest deterrent of criminal offending, which is why it is quite often said that diversionary processes would be soft on crime. And that tends to be the biggest opposition to using these schemes more widely. That then leads to the view, this idea of soft on crime, that diversion very much has a bad image problem. And you see that come out from some recent research. Some 2,000 people who were surveyed about diversion, one of the main findings last year were that they just didn't even know what diversion meant. That term had very limited value. A particular senior police officer said, and I think this sums up what a lot of people do think, what justice really should look like is based on old-fashioned views to do with court hearings and prison sentences. And people are less familiar with out-of-court disposals. Interestingly, notwithstanding the court backlog figures, which are often reported quite widely in the media, when this idea of diversion could be seen as a way to administer swift justice was raised with people surveyed, there was then a lot of response saying, well, that would mean that justice would be rushed, and that would not be right. So not really the support that certainly the surveyors expected. The research that was conducted last year also revealed that a lot of people in the community have quite a complicated perception of the courts and their role. On the one hand, it can be very isolating and feel like it's another world in terms of it being slow and stressful, it being very unfamiliar. But equally, there was understanding that it was the bedrock of our system and needs to be preserved. Therefore, ideas about diversion didn't actually get the support that one might have thought. That said, so notwithstanding that there is this public perception that diversion is about being soft, there have been a number of very interesting pilot programs which have first been pioneered, and where they've been successful have been rolled out more widely. And I've picked only a few of them because these are the most recent, but there are similar programs in other boroughs and areas throughout England and Wales. If we look to one of the most recent, you had, well, just last month now, plans that were announced to launch a pilot program here in London to divert young offenders aged 18 to 24 who are picked up for cannabis possession. So that is a limited trial involving 3 London boroughs in and around Lewisham. The idea being that we shouldn't have over-criminalisation of drug possession, and that has been announced and is going to be rolled out this year. That proposal came out of a report which was published by a independent research organisation who talked about the need to divert people, work out the root causes of the offending in the first place. Also, and Thames Valley Police in particular have done a lot of work in diverting people away from the criminal justice system. You had in 2019 through to 2020 another of their drug diversion pilots. What was interesting about this one in particular is that it was not just for drug offences at all, but rather it was rolled out more widely, and the eligibility criteria was not so strict. In terms of the mechanics of it, it involved a deferred summons approach, whereby a police officer using their body-worn video would conduct the interview with the offender, and the summons would be deferred if they successfully completed a particular course, which was all targeted at rehabilitation. As I said, the eligibility criteria wasn't restrictive. It was open to people regardless of their prior convictions. It wasn't targeting just young offenders. It was also targeting matters to do with knife crime and also crimes that are committed by adults. And there has been some success. So some of the comments that were made by the chief inspector who runs the program in 2020 talked about some 40% of adults who were offered that course did complete it. They then received the deferred summons, and that was some 10% over and above the national average for other community resolutions. There were problems because there were logistical issues with getting people to the course, them being able to take it up. But they certainly were quite encouraged by the findings of that pilot. And there is also talk of more pilots and programs being introduced. The point was also made that it was particularly successful when it came to youth diversion. Another interesting program, again very recent, is the female offender diversion pilot, and this will tie into some of the diversion of women from the criminal justice system, which Laura Jane is going to be speaking about. But this particular program was a Met Police program, which was launched in 2019. The rationale for that was about diverting women offenders away from the criminal justice system. The reasons for it were because of the 17% or so of women who are arrested by the police. So of all of those arrested, 17% are women. And a number of those do have very complex needs, are very vulnerable. They also have dependents. Recognizing that, I think what was quite concerning, given we're now in 2022, was that back in 2019, 2020, there was absolutely no mechanism for police to refer women to particular support programs or women's centres. There was no framework in place at all. But this was introduced to set the ground for that framework. And in four areas, this program was designed to allow female offenders to receive community resolution or maybe a conditional caution, to refer them to local women's centres and make sure they get specialist support. The types of offences there were things like theft and shoplifting. Now, in terms, so that's just three, and I've just picked three random ones, which are quite recent. But the point to highlight, I think, from all of them is that there are programs that do exist. The point, I suppose, is about knowing that there could be, knowing that the majority of police forces do offer diversion in some capacity. And if you are involved in that very early stage, or even throughout the life of proceedings, if a person is charged, just to see if diversion is an option. Other practical tips, I suppose, is to not be deterred. On close looking at some of these diversion programs, a number of them do remain suitable, even if a person comes with a lot of prior convictions. Just because they have a record, they're not necessarily excluded. And although I think the dominant view is that diversion is just for young people, or it's just for very minor drug offences, it does seem to be available, depending on the police force, for other things as well. Now, we haven't spoken too much about formal types of diversion, such as cautions, because I know all on the call will be very familiar with that. But just a word about the use of diversion schemes and what happens if diversion is offered after a person has been charged. Certainly, quite often it might be in the form of a caution if you get to that point where you're quite advanced in a criminal proceeding. What then is the costs implication if that proceeding is then the subject of no evidence being offered? This here, certainly Section 16 of the Prosecution of Offences Act doesn't prevent a defence costs order being asked for and indeed being made. No prejudice should arise just because the defendant didn't seek the caution in the first place, or perhaps raised it at a late stage. Ultimately, if that person is diverted, whether it's in the form of a caution or something else, and no evidence is offered, that will still mean a formal verdict of acquittal should be entered. The only exception to that will be if the court identifies a positive reason why a defence costs order should not be awarded, and the practice direction sets all of that out. in terms of case law, and tonight's session is not at all case law heavy, but if you do get to that point and the proceedings have been instituted and then they're dropped because that person is diverted, then there is case law to support that defence costs orders should be made. There's a case of Stoddard, which I've put the reference to on the slide, where there a caution was offered at a very late stage. The district judge refused defence costs because they saw that the charge was going to be quite rigorously defended. The caution happened very late in the day, but on a case stated to the High Court, the High Court very clearly said that it doesn't matter. It is still an acquittal, and certainly even if the matter was going to be rigorously contested, when that caution was offered, it was only right that the defendant think carefully about it. And if they chose to take it up, it's still no evidence offered, and defence costs should follow unless there's a positive reason not to. So I hope that that is helpful. I'm now going to hand over to Laura, who's going to take us through some of the detail of youth diversion and drug diversion.
Thanks, Anita. There we go. So drug diversion, from harm to hope. This is basically, I just want to give a brief overview about the government drug strategy that was outlined in December 2021, and a quick overview, and then the impact on the courts and the potential for whether we want to call it diversion or out of court disposals in terms of what have been deemed recreational users of drugs. So in effect, what the government did in December 2021 was they announced their 10-year strategy to combat drug use and crimes stemming from drug use, not just drug dealing or drug possession, but acquisitive crime that often goes hand in hand with drug use. And as will be anticipated, if you haven't already read it, it very much is the government saying we're spending all this money, this is exactly what we're going to achieve. And in effect, they are talking about crackdown on your county lines drug dealers, on drug importation, but also tougher sentences for recreational users. And what I've got on the screen now is effectively their 7 steps as to what they seek to achieve in the next 10 years. And what they're going to do is they're going to start by looking at the areas most affected, they say, by drug usage. They've looked at the different police forces and the impact of opiate and crack cocaine use in various areas. And that very much is going to affect the rollout of this strategy in various different areas. And it very much will be a local area approach. So again, we're likely going to see, this postcode lottery that Anita's already touched upon in terms of the rolling out of the helpful parts of this scheme, but also the imposition of tougher sentences and stricter sentences in terms of other aspects of the scheme. So effectively, what the government want to do is they want to take a multi-prong approach into tackling drug usage and drugs in England and Wales. There's going to be further investment in the NCA, further investment in financial investigators, further investment in the police in order to investigate and to prosecute drug offences. There's also going to be approximately 21,000 new places in treatment centres, and also approximately 7,500 new places to assist people who are sleeping on the street or are an immediate risk of sleeping on the street. There's going to be more education in schools in terms of the impact of drug usage and the negative impact of drug usage, even recreational drug usage in the community. But one aspect that somewhat links into diversion, although the defence practitioners among us may not necessarily think it's a diversion in the usual sense, is that the government very much want stricter sentences or stricter consequences for recreational drug users. And they estimate that the typical recreational drug user may use Class A drugs approximately 30 days per year. And at the moment, they consider that the consequences of recreational drug use are not being properly felt, so are not being a deterrent to those drug users, which is then fueling the drug problem, the drug supply problem in England and Wales. So going forward, what they want to put in place is that if you are caught with drugs, you might first have to undertake a drug awareness course, which you can be told to do by the police. The police will have greater powers to fine people, to make people work within the community, to undertake drug treatment. What the strategy envisages is that some people may need more than one chance to turn their life around, and various pre-charge measures can be put in place. And it is of note that the drug awareness course, the fines, the drug treatment, the working in the community, as it is currently envisaged, would come before the imposition of a caution, and obviously would come before the decision to prosecute. So whilst the government are saying it should be tougher sentences for people who use drugs recreationally, in reality, what it may do, or what it should do, is allow people more opportunities prior to being issued with that caution, prior to being prosecuted, to move away from the criminal justice system. It's also anticipated that there will be substance misuse courts. So when people do enter into the criminal justice system, there are specific courts that will deal with those matters. They will be drug specialists who are attached to those courts, and also to assist probation in working with people who have addiction to Class A substances or Class B substances, or drug addiction in general. But the other aspect is a lot more offences are going to trigger drug testing at the police station. The courts, it is envisaged, will be given more power to order drug testing linked to community orders. Whether or not the defendant agrees to be drug tested or not, there would be the power to order drug testing, and to, as would happen now on reviews, come back before the same judge and have a review at regular intervals with the drug testing. A positive test, it's envisaged, could lead to a breach of the order, resentencing. The strategy in fact is resentencing to a period of imprisonment. it is also envisaged that when somebody is arrested for drug dealing, their phones will be interrogated as they are now. However, as an additional aspect, their customer base, based on the telephone numbers recovered from those drug lines, will be sent messages telling them how they can seek assistance and to discourage their use of controlled substances. So there's a variety of different measures there. The ones that relate to diversion from the criminal justice system are what I have outlined. But there are additional measures in effect, helping people in custody with their reintegration into the community once they have finished their sentences, the better partnership between the drug and alcohol services in the prisons and the community-based drug and alcohol services, and injecting more money into treatment programs in the community. So it's not all doom and gloom, but at the same time, whether or not it will have the impact that they envisage is another matter, because it very much is that the postcode lottery, the local level, the government at local level, working in partnership with the relevant agencies and committing to bringing this about, which if different schemes in years gone by or anything to go by, may very much mean a postcode lottery again in terms of drug strategy. I want to move on quickly now to juveniles. I appreciate I'm going through this at quite a pace, but it's just because in fact, the topics that we're going through today are very much could have their own webinars, and to have 20 minutes, we are going to have to go through it at a bit of a pace. But moving on now to youth diversion. As you know, youth diversion schemes are a way of addressing low-level criminal behaviour. There's a raft of evidence that youth diversions are more effective in preventing further offending, rather than young people going into the criminal justice system. That may be common sense, but there is a lot of evidence of it. Youth diversion, the first on the scale is a triage, then a community resolution, youth caution, or youth conditional caution. Now, when making representations to the police, and I'm a firm believer, being a police station accredited representative, having been a defence solicitor for some years before transferring to the bar, that making early representations to the police and to the prosecution can make the difference, certainly for young people. And when making representations to the police and the prosecution, I'm also a firm believer that we shouldn't assume that they are aware of all of the provisions, and that written representations can be very helpful. Now, as you know, the principle of the youth justice system is to enhance rehabilitation. The welfare of the young person has to be taken into account, and really in all cases, the prosecution and the police should be considering whether or not a diversion could be put in place for that young person. And that is so even if they have a raft of previous convictions, they are required to consider it, and they're required to include in their review why they are not able to put a diversion in place for that young person. Now, decisions to prosecute young people must be made by a youth offender specialist. That is not something that prosecutors are always aware of. So if you have a prosecutor at court and they're making decisions about whether or not to prosecute, it's always worth checking that they do have the required accreditation. And a decision to prosecute is open to judicial review. And before making the decision to prosecute, the prosecution or the prosecutor should make sufficient inquiry about the circumstances of that young person and their general character. So again, it's always useful, in my view, to include the history, the background, and any relevant material in terms of that young person in representations, because they do have to show that they have made inquiries, and that includes inquiries by the police, children's services, and with the youth offending service. Now, in terms of triage, young people who get into trouble for the first time or for less serious offences can be dealt with by the informal process of triage, which can include and does include them attending at youth offending service appointments. And triage is dealt with on the police computer system as an NFA. And often that is the best way for a young person to be dealt with in the first instance. It allows an engagement with the youth offending service prior to them coming into the criminal justice system. Community resolutions are used throughout England and Wales, as Anita said, and it's a victim-focused outcome, which I'll just pop my slides back on. A victim-focused outcome. Now, Met policy does dictate that community resolutions cannot be used for domestic abuse, hate crimes, sexual firearms offences, or weapons offences. That doesn't necessarily mean that they never will, but that is current Met police policy. A community resolution does require the young person to accept responsibility for the offence, and they must also offer an act of reparation, being that an apology or repair of financial remuneration. And a community resolution can be imposed if the officer feels it's the right thing to do. You can, as I've said, make representations in respect of community resolutions. In my experience, officers don't always appreciate that they have to, in fact, have an admission of guilt, and also that they have to be able to prove their case. I recently made representations on instruction because the police were trying to, in effect, force a community resolution on a young person. And when I looked at the case and made representations to the effect that, in fact, they couldn't prove their case for starters. And secondly, there hadn't been an admission, although he had said sorry, and that, in fact, in the circumstances, was not an admission of guilt. And I was instructed to make representations because he didn't want to go into the criminal justice system, but also he didn't want to accept the community resolution, which could, in years to come back on an enhanced DBS check. So whilst it might seem odd that I was trying to argue against a community resolution, there was a method in the madness. And in fact, they ended up NFAing the matter. So that was a good outcome. But it's always worth just reviewing the matter and making those representations. Now, the views of the victim must be considered in the decision-making process for community resolutions. But even if the victim is not on board with a community order, in exceptional circumstances, a community resolution can still be imposed. It's a victim. Their views must be considered, but their views are not overriding. And in fact, as you will know, there can be a community resolution imposed for victimless offences. As I've said, community resolution will come back and be disclosed in an enhanced DBS check. That should be DBS check, not BDS check. Community resolution is not a criminal conviction, does not result in a criminal record, it's not recorded on PNC, but can be disclosed on request and be relied on as part of a bad character application. A previous conviction does not preclude a youth from receiving a community resolution as long as it's a justifiable outcome. And a youth may be given more than one community resolution. From the 1st of March 2018, the Met have adopted the use of community resolutions to deal with offensive possession of cannabis, which would have previously been dealt with by a cannabis warning. To be eligible, the offender must accept responsibility, and in this case he must have no prior convictions, cautions or community resolutions for possession of cannabis, or have been issued with a cannabis warning between the 26th of February 2009 and the offence date, and must agree an act of reparation, which can be reading the information on how cannabis can have a negative impact on your future. And the reason why for a community resolution for the offence of possession of cannabis, you cannot have the previous conviction, caution, community resolution or cannabis warning, is that under the old legislation in terms of cannabis warnings, it had to be a first offence. So that's why that is slightly different. Also, just be aware, anybody under 18 found in possession of cannabis must be referred to the Youth Offending Service to determine any out-of-court disposal. Now, moving on to youth caution, warnings and reprimands, as they were abolished nationally in 2013, and now we have youth cautions and youth conditional cautions. Police must refer a young person who's been made subject of a youth caution to the Youth Offending Service, but it can be imposed, a youth caution can be imposed for any charge so long as the statutory criteria is met. And that criteria is that the police are satisfied that there's sufficient evidence to charge the accused with an offence, that they admit the offence, that the police do not consider that the young person should be prosecuted or given a youth conditional caution. Again, there's no statutory restriction on the number of youth cautions a person can receive, and a youth can receive a youth caution even if they have criminal previous convictions. But obviously, if they've got convictions for like offences, if they've had previous cautions for like offences, there may be more of an uphill battle to convince the officer that a youth caution is appropriate in your case, but there is no statutory preclusion from doing that. If it is for an indictable offence, then the CPS must be consulted, as with youth conditional cautions as well. Now, the offence serious is determined by a gravity matrix. Now, I've put in the link there from the Youth Justice Legal Centre website for the gravity matrix, if anybody does want to have a look at it. But just be mindful that although it is of primary relevance, if a deviation is justified, the police do have a discretion to deviate and can apply aggravating and mitigating factors depending on the case itself. Conditional cautions. Again, an authorised person must have evidence that the young person committed an offence. The prosecutor must be satisfied that there's sufficient evidence to charge. The youth must admit the offence to the authorised person. The authorised person, usually a police officer, must explain the effect of the youth conditional caution to the youth and warn them that failure to comply with any of the conditions may result in prosecution. And if the youth is 16 or under, this must be done in the presence of an appropriate adult. The youth must sign a document that contains the details of the offence, an admission that he committed the offence, consent to the youth conditional caution, and the conditions must be attached. Now, when the matter is within the court setting, but the prosecutor is of the view that a youth caution or youth conditional caution is or may be justified, then the matter should be adjourned for such a disposal to be considered. But the prosecutor should not give an expectation that will be done. Now, on the point of the female offender strategy 2018 and the update from 2020 and further funding that was announced in January, the government very much do want to work with female offenders who make up a relatively small proportion of the people coming before the criminal court. Now, this is a work in progress. It is something that is being looked at. Zoe's turned her camera on to tell me that I'm running out of time, so I'm going to talk even more quickly. Now, I found Advanced Charity online. This is a service that's working with the Metropolitan Police to provide a diversion for women in the criminal justice system, and which includes the use of a conditional caution. So that may be something to have a look at if you are working within the London area. And also, you may have heard of to be quite frank, horrific, the two cases which hit press attention in 2019 and 2020. The first of a young woman who had in fact asked to be remanded because she was heavily pregnant and ended up giving birth by herself in a cell in Bronzefield, and by the time prison staff came to see her, her baby had sadly passed away. And also a 2020 case of a baby being stillborn in custody. Now, both the investigations into those two instances, and they are not alone, there are more than those two instances, but those investigations concluded that there are multiple failures in the system within those cases, and it's accepted more widely that there are inherent failures in the system when it comes to pregnant women in custody. And research has identified that pregnant women in custody are 5 times more likely to suffer a stillbirth. And part of what the female offender strategy wants to do is to try and divert pregnant women away from the criminal justice system. And again, this is a charity that I found online, Trevi, which very much tries to assist pregnant women in diverting them away from custody and provide an alternative to custody for them. And I think I'm out of time now, so I'll hand back to Zoe.
Great, thank you very much both. That was extremely interesting. Unfortunately we've just gone past the hour, so I don't think we've got time for a live Q&A, as it were. If you do have any questions, perhaps you could send them via email to us. I'm sure we can provide attendees with a suitable email address in due course. But for the time being, thank you very much for attending, and hope to see you next time on the 21st of April.